Hello, and welcome back to Legal Opinions with Clementina. I remain your favorite lawyer, Clementina E. Ukiri Esquire. Yes, I bring to your table today a fantastic conversation in respect to land transaction. In a situation where a vendor of a land, the owner of a land, and a purchaser of a land have different lawyers representing parties, what then is the role or the duties of each of these solicitors? Let us begin with the vendor's solicitor. A vendor solicitor prepares a contract of sale of land. A contract of sale is an initial or preliminary agreement between the purchaser and the vendor, the seller and the buyer, if that makes it clear. And the contract of sale states the initial terms and conditions that will guide the sale relationship or the transaction over this land. For instance, Party A is ready to sell to B this piece of land in Ikoyi, Lagos. Party A has this root of title, and attached to the contract of sale are evidence of Party A's root of title, the deed of assignment, certificate of occupancy, the purchase receipt, or a court judgment, or an instrument of ownership granted by an executor of a will to transfer the title of the land to Party A, who is now the vendor. In such a circumstance, when these documents are attached to this contract of sale, the terms of the contract of sale will state further that the purchaser is now at liberty to use this exhibited or attached proof of title to do due diligence. Go to the land registry, go to anywhere you want to go to the court registry to find out if indeed the title of this property is genuine. So yes, the vendor solicitor prepares the contract of sale of land. 2, he advises the vendor on all the stages of the transaction. This is what you do at this stage. This is what is happening now. You keep them updated. You manage expectation. You manage the relationship between the vendor and the purchaser and his solicitor. 3, the vendor solicitor receives deposit payment for the property from either the purchaser or his or her solicitor until the balance payment is made. It is easier because, assuming there was a breach or one of the parties pulling out from the transaction, it's easy for the solicitor to refund the money as opposed to giving the money straight to the vendor, who may tamper with it while the transaction is yet to crystallize. The 4th role or duty of a vendor's solicitor in a landed transaction is to deduce title on behalf of the vendor. Deduction of title means establish, prove with evidence to the satisfaction of the purchaser and his solicitor or her solicitor that yes, the vendor has a good root of title, a sound title to the land. Then, of the vendor's solicitor is to prepare the abstract, an epitome of title. Imagine if you want to deduce your title. You want to prepare a historical analysis, clearly written, with evidence or attachments, documentary evidence, to prove the title of the vendor. So that is the abstract, a write-up showing and proving the sound title belonging to the vendor. Now, the purpose of deducing title is to show what? A good root of title. Now, what is the role of a purchaser solicitor in a land transaction. Upon the conclusion of investigation and having satisfied yourself as a purchaser that you want to proceed with this transaction, it would now be the role of a solicitor to first conducting due diligence and investigation of the purported title of the vendor. And the solicitor to the purchaser also advises the purchaser regarding all the stages of the transaction. The solicitor manages relationship between the purchaser and the vendor and his solicitor. Purchaser solicitor could also pay money for property on behalf of his client to the vendor's solicitor or to the vendor directly. But very importantly, purchaser solicitor must engage in the skills of due diligence and investigation until he satisfies himself of a good root of title. And finally, the purchaser solicitor must, as a matter of precedent and case law and principle, prepare the deed of assignment. And if there is any reason, valid legal reason, why the purchaser's solicitor is not preparing the deed of assignment, which is the deed of transfer, the instrument of title being passed, then the solicitor must review every word, every dot, every T that is crossed must be seen, reviewed, commented upon by the purchaser's solicitor. The principle that guides this is very simple. Who is the person that prepares the land transaction document or deed of assignment or any land transaction instrument? The answer is this: that party that will suffer most loss if the transaction fails or there is a breach or something goes wrong with the transaction. That party that will suffer most loss. In the circumstance of a contract of sale, we must understand that if the transaction at that stage falls through, the vendor suffers more. Imagine giving a copy of your C of O, your survey plan, receipt of purchase, deed of assignment, or all of those relevant documents that deduces your title to someone who goes ahead to use it for fraudulent purpose. Having realized that the property has a good use of title, counter your monetary offer of the value of the property with a lower bargain, being a far cry from what was initially agreed. So, a contract of sale ought to put down modalities to stop such behaviors from purchasers. So whatever the value you have agreed before going for your due diligence, you must maintain that value. Same thing applies to the vendor. The contract of sale also makes sure that parties come back within a certain period of time from whatever investigation they are doing. You can't do a land investigation on someone's property who is in the market for 2 years. Nobody's going to wait for you. So there should be a timeline within the contract of sale to say, you do this, but you have 3 months to do that. After 3 months, you'll be free to sell this property to someone else and refund you your deposit payment. Less or so amount for the time wasted. That is clear now. So the party who will suffer most loss in any transaction, be it a land transaction, should be the one to prepare or supervise the preparation, or should be the last person to look at the transactional instrument. This is where it is of importance. It is paramount for the purchaser's solicitor, who would become the assignee if the transaction crystallizes, to prepare the agreement, because at that point where he or she has parted with the money, for the sale. It will be difficult for you to recover the money if the transaction falls through. Representations are found to be false in the future. So it is best to prepare your document, put in what protects you in the document, and then have parties execute the contract or the deed of assignment. We'll take about from this lecture. It's going to be a series on land transaction, due diligence, and all of that. The role of solicitors, it's going to be a series, and we can call it a day from here. Until later, bye for now.